To discuss, we're now joined by legal analyst Mpumelelo Zikalala. Thank you for being with us, Mr. Zikalala. This latest delay is effectively to allow Zuma to exhaust all his legal avenues to have Billy Downer removed from the prosecution team. Is that correct?
Definitely. In fact, what the former president is saying is, I want this matter to be discussed or to be further analyzed by a court which is higher than the one in Pietermaritzburg. The Supreme Court of Appeals must listen to this matter. The judges that dismissed it, I think they were wrong. They didn't look at all the factors in which they were supposed to look at. And it was just a simple dismissal without interrogating the facts, which is why I've then written to the judge president, Justice Maya, to say to her, please reconsider this particular application. If needs be, I'm even prepared to come and argue so that you can see my point of view pertaining to this particular point. Secondly, is that if he then fails in that one, he still has a constitutional court to go to, in which he can then go to the court and say, understand my definition of charging the prosecutor is not only limited to the documentary or the administrative processes, but it is further extended to the conduct of the prosecutor. Should a prosecutor that has conducted themselves in this particular manner be fit to prosecute me in these particular applications? If you find in my favor, what are the results of that, pertaining to you acquitting me based on that procedural irregularity? So that was basically what the former president is saying. And in this case, the court's hands were tied, because once an appeal process has been engaged in, there's nothing that the judge listening to the matter in the court can do. Yes, they do have a discretion of continuing, but that discretion is likely used or sparingly used, because they don't want to change the matter. They don't want to change the procedural expert when it comes to legal compliance, because this is one of the things in which, on appeal, the person who has been aggrieved, when the accused has been aggrieved, can make it a very first point of appealing that matter and saying, just look at how unfair I was treated. Yeah. My rights as per Section 35 were infringed.
So if that application can go all the way to the Constitutional Court, then presumably we could see delays beyond the 17th of May or even the end of May.
Definitely, which is why the court was very clear in terms of saying that the 17th of May is purely a holding date. And also, I think also the 31st of May will also be a holding date, so that at the end of the day, they're able to come back with much more plausible time frames. What the court was clear, though, in which the court has alluded to before it handed down its judgment, was saying that we are going to provide judicial oversight in this matter. We're not going to let it be or let the dates simply pass on as if we're not watching them closely. So we want you to come back in 2 dates in May, so that you can be able to come back and give us progress. Where are we in terms of the SA decision? If you are happy with the decision, if you are not happy, come then and tell us on the 31st what do you intend to do, or whether you want to go to the court or not, or if you've been given reprieve. Let's see what's the next step that the NPA can take.
Let's look at what the state said today. It said that the defense, Zuma's team, was again employing delaying tactics. Billy Downer himself said there have been countless applications, all of which have been refused. But I guess the courts in this country put no cap on the number of applications that can be brought before the trial goes ahead on the actual merits.
Definitely, but you see, what the court will then do in those instances, it would say, for us to be able to achieve ultimate justice, for us to protect your rights as per Section 35 of the Constitution, you must be able to use all the legal avenues that are there, which is why Judge Kuhn was at pains in terms of explaining that these are our rights which are accrued to the accused. So the mere exercising or choosing to use those particular rights, not instances of saying that you want to avoid your day in court. Yes, you do want to get your day in court, but you want it to be done in a manner which is in compliance with the law. So if those avenues are still there, they are still open, they still can still be utilized by the former president, definitely is going to use them, because it's going to provide an assurance to him and also to us as members of the public that definitely our law is working, our justice system is working, and you can be heard at any given time if you think that procedurally your rights are being infringed.
All right, there are mixed views on how devastating it would be anyway if Billy Downer was removed from the case. What is your view?
Not really. Let's remember that the removal of Advocate Pietermaritzburg does not mean that he's not going to provide the institutional knowledge that he comes with. So he can still be there, employed by the NPA, can still be able to chart the way in terms of providing crucial information as to how the Shabir Sheikh matter was handled. Let's also remember he was the lead prosecutor in that particular matter too. So would know and understand even the type of responses that were given. So the evidentiary material, it is closely linked to Advocate Pietermaritzburg. But in this case, if it's removed, it does not mean that the state case is going to fall flat. It's simply based on the type of evidence that the state is going to produce, what the witnesses can or cannot remember, which is another thing in which I think both parties should be focused on. Because let's remember, the quality and the quantity of the evidence is very crucial. Maybe more crucial for the state in this case, because they have to prove beyond reasonable doubt that the former president is indeed guilty. Now, if you're going to find individuals who are going to forget the sequence of events, documentary evidence which is going to go missing, it certainly works against the state in certain instances. But whether Pietermaritzburg is there or whether Pietermaritzburg is not there, there's nothing which is going to stop the state from prosecuting this particular matter.
All right, well, we'll follow this legal process and like we've been discussing, it could mean further delays for this year. Finally, there was a medical emergency which meant that the former president wasn't in court today. We don't know the details. But and we saw the judge there say he didn't have to appear on certain dates when they're just looking at future dates. But what if he's actually too sick to stand trial? Does it go ahead in his absence?
It's only in very special circumstances in which the trial would go ahead. Let's remember, the rights in which you are trying to protect under Section 35 mean that you must be there in court and be able to see and hear the evidence which is being laid against you. Also must be there in court and be able to give immediate instructions to your legal team whenever the need arises. So if you are not there in court and you can't be able to defend yourself or to understand or appreciate the processes which are taking place, it is definitely something that has to do with the unfairness of the trial that you are going to be facing. So yes, the trial can continue without the former president, but it's under extreme circumstances where the court will say we are going to continue with that particular process. Again, before it takes a decision, it would need extensive medical reports, medical experts that will then come in and then say the former president is not fit to stand trial, and in the hands we can't continue. But I don't see the court coming to that decision. I see the court saying we're going to wait for you up until you get better. We're going to keep conducting these inquiries, seeking medical expert opinion as to whether you are fit to stand trial, so that we want you to be present when evidence is being laid against you. We want you to be present when you are giving evidence, so that at the end of the day we can determine your innocence or whether you are guilty or not.
All right, well, thank you for providing clarity as always. That was attorney and legal analyst Mpumelelo Zikalala.